Now I think we can go to the Q&A section. We still have 20 minutes left. I think we have a question now from Ibu Dewi Susanti. So Ibu Dewi has a question. What are the most significant legal challenges commonly encountered in resolving construction disputes in major infrastructure projects in Indonesia? I think this question should be for Dr. Eddie. And then based on your experience, the second question, do you prefer litigation or arbitration for resolving construction disputes, and why? I think the second question can be for both Prof. Inba and also Dr. Eddie. Thank you.
Okay, thank you, Bu Fitri. I will start first. So the most challenges, major construction disputes in Indonesia. I may not have the very full experience on this, but from my experience, what is problematic is the consolidation disputes, because I experienced a dispute between project owner and the main contractors, but there is also unresolved matter between the contractor and their subcontractors, or sometimes joint contractors. So it is not a main contractor with the subcontractor. Sometimes there are two contractors jointly in a joint operation agreement, for example. So I experienced that in the joint construction agreement, they have a separate dispute resolution clause than the project agreement between these consortium contractors with the project owner. So this, and then there are disputes. Yeah, there are disputes between the contractors, and there are also disputes between contractor and the project owners. So these are the challenges, I believe, because it may create inconsistency in an award between the disputes among the contractors and the disputes between the contractors and the project owners. This is one thing, inconsistency, and even it is even worse. It can also be challenged in relation to the nebis in idem principle or res judicata, because some issues in the two disputes may overlap. And of course, this is also related to the confidentiality of the award. But when that happens, these overlap issues can also be problematic, because these two proceedings may have a similar problems that should be examined by different tribunals. So I think that is one of the huge problems that we face in the construction dispute. And the next question is on which method I prefer. I think it depends on the different factors, of course. In my personal view, I would prefer to choose always arbitration than litigation. But when I advise that to my clients may not necessarily agree to it, because they also consider the cost factor. We understand the arbitration costs may generally be considered more expensive than the litigation cost. So of course, there is an issue of privacy and confidentiality if the clients regard those factors highly, and complexity, and also the specialization required to resolve the dispute, they may go to the arbitration. But if these are not regarded by the clients, they may just proceed with the litigation. So I experience both ways actually, even though my personal view is I would rather choose arbitration than litigation.
Thank you, Dr. Eddie. I think we still have 15 minutes, but there are a lot of questions. So let's try to answer some of it. But I think the rest later on, we can probably have it offline. We can answer it through through email. So we can hopefully BIMC can give Prof. Inba and also Dr. Eddie their email address. But I think there are two questions now that we can ask for Dr. Eddie again. What are your views on BAPATSKI, Badan Arbitrase and Alternatif Penyelesaian Sengketa Konstruksi Indonesia, for construction disputes? Would you choose BANI over BAPATSKI? And then for Prof. Inba, I think Prof. Inba can start first. From anonymous attendee, what advice would you give to to companies to better prepare potential disputes from early stages of a project? Prof. Inba, can you answer first? And then after that, Dr. Eddie on BAPATSKI over BANI. Thank you.
Yes, yes. Thank you, Devi Savitri. Regarding the first one, which I'm obligated to respond. Out of my experience, when it comes to construction contracts, which one I prefer, arbitration or litigation? My answer is very simple. Most of the construction contracts simply adopt the standard forms of contract. And all these standards forms of contract, whether it is within the country or beyond borders, when you're going to get involved with experts and contractors, it is very simple. Those standards forms of contract eventually leads only to arbitration. There is no other choice. We have to be prepared to arbitrate. And coming to the second part of the second question, how to avoid disputes, and particularly in construction sector, the answers are multiple. Dispute avoidance or the mitigations of disputes are very two different theories, what we have to really understand. Dispute avoidance, no doubt, one thing, disputes are inevitable. As lawyers, understanding whether it's going to be vetting a contract or whether it's going to be implementing a contract, disputes are inevitable. At some point of time, there will be some issues which might be leading to disagreement between the parties. It's not breach as such. But in construction industry, how to avoid disputes? The best thing, as rightly Dr. Eddie also was mentioning about the FIDIC 1 of DABs, the Dispute Adjudication or Dispute Avoidance Board, it might not be practically workable, but if we effectively implement those DABs at the initial stage of the project, that's very important. The DABs should not be invoked after the dispute has arisen. At the time of executing the contract, along with the contract, when we just go with these DABs and when we have regular meetings with these DAB members who are going to give recommendations, that recommendations can minimize the disputes to be escalated. That's one very interesting point. Another point, dispute avoidance, how to avoid disputes in construction. It's all about how we are going to maintain contemporary records. The project manager in the site or the legal professional, in-house professional who's going to guide that project manager in day-to-day implementation of the contractual obligation, if they can maintain perfect contemporary records by responding, communicating, acknowledging each and every communications, then that also would lead to effectively mitigate disputes. Not only that, we can also avoid disputes in construction industry.
Yes. Yeah. Thank you, Professor Inba and Dr. Eddie, about BAPATSKI over BANI or even BIMC.
Yes, okay. Well, I'm not familiar with the BAPEX key. What I'm familiar is with the BANI rules. So I understand that Bapepski is specializing on construction sector more than Bani, because Bani is more general. So I think I will advise you, because I cannot say which is better or which is more suitable. I think I would advise that you see the rules, yeah, because that will be applicable when the parties choose which institution and then which institutional rules applicable to them when they arbitrate. So just understand that you have to be aware of the rules. You are comfortable with the rules, and then yeah, it's up to the parties to choose. Yeah.
Thank you, Dr. Eddie. And then let's go to Arlini's question. I think Prof. Inba can answer this. To what extent is the traditional emphasis on selecting a neutral governing law and seat still relevant if ultimately the success of arbitration hinges on enforcement in jurisdictions that may have different public policy thresholds or judicial attitudes towards arbitral awards? And then for the question from Aulia, Dr. Eddie can answer on how can construction contract disputes with the government as the project owner be accommodated, considering that government projects often use their own contract concepts and sometimes allocate risk unevenly. So please, Professor Inba.
Regarding this neutral seat, it is the principal reality of any international arbitration that we can't just change. The neutrality, it is not only on the seat, as you rightly mentioned, it is all about the particular seat, the neutral seat, which is also going to overcome the reservation in the treaty, particularly the New York Convention. As Dr. Eddie was mentioning, even I also just missed out, even in Indian jurisdiction, when it comes to international award, in Indonesia, the foreign seated awards are identified as international award. In Indian subcontinent, it is identified as foreign award in the names of the New York Convention. Either way, when it comes to enforcement, it is always better to go with neutral seat. Why? Because in addition, we have a rider wherein reciprocity is very significant. If the jurisdictions, particularly the neutral seat, has a reciprocity arrangement along with the New York Convention, most of us would be familiar on it, whether, assuming that India and Indonesia have the reciprocity, whether India and Singapore has a reciprocity, whether Singapore has and Indonesia has a reciprocity. These are all very significant one when we are going to choose neutral seat. Neutral seat is inevitable. We can't just avoid it. Why? Because another thing, we need to have neutral country arbitrators also. It is not that we need to have the nationality of the respective parties or one parties, so that might create a red flag on the conflict of interest. To avoid that, it is always better to go to neutral seat. Additionally, the New York Convention also is very clear. And when you look on the model law, the mandate stipulated when it comes to appointment of arbitrators, I'm not so clear about the Indonesian jurisdiction. I think Dr. Eddie might highlight on it. But generally, the model law principle is very clear. When it comes to international arbitration, whatever the nature, whether it's construction or commercial, when it comes to those arbitration, the third arbitrator or the presiding arbitrator, the chairman of the arbitral tribunal, have to be from a nationality which is neither the claimants nor the respondent.
Thank you, Professor Inba. Dr. Eddie.
Yes. Okay. Well, yes. It might be challenging when negotiating with the governments. They have their standard document according to the regulations. Yes, it is But what I understand, there is always a chance to negotiate the terms and conditions, especially the commercial items requested when the offer was submitted. Of course, it's not always be successful because the government institution may just say that we cannot accept any deviation from the standardized clauses and standardized contract. So if that is the case, then of course there is no other way to understand the risk, commercial risk, legal risk, and whether you are comfortable with it. Yeah, because if you are not comfortable, it is better to just withdraw from the agreement. But if you understand the risk and you are comfortable with it, then you still can proceed, even though the terms cannot be negotiated as what you expected before.
Okay, thank you. I think let's have two additional questions. From Nadine, Professor Inba, can you answer with increasing uncertainty and complexity in large-scale infrastructure projects? Do you think traditional tiered dispute resolution mechanism are still sufficient, or should they evolve toward more adaptive systems such as the real-time dispute boards or hybrid ADR models to better manage disputes proactively? And the question from William Alexander, if Dr. Eddie can answer it with regards to the decline of national budget portion for PUPR. Do you think it will have any effect in construction dispute in its scale? If so, will there be more or less disputes in the coming years? Professor Inba.
Yes, yes. When it comes to the interesting part of multi-tier dispute resolution mechanisms, whether we had to change from it and move to any hybrid clauses or the recent developments, my answer is very simple. We can literally adopt the principles in some jurisdictions, civil law jurisdictions, wherein we have mandatory institutional arbitration. That is the only solution you can say. The mandatory dispute resolution clause of multi-tier or the normal arbitration clause of institution, when we adopt, as earlier in the presentation where I highlighted, many institutions subject to the neutral seats advancement and acceptance of emergency arbitrator. When we have the emergency arbitrator provisions adopted in those institutional rules, very well, those arbitration clause would be helpful. This is one. Another one, or an answer to your query, you can say. It's not actually a Q&A. It is all a pro bono opinion, what I can give here. It is very simple. Still stick on with arbitration. Whether it is going to be a hybrid one or the multi-tier, the traditional one. The courts might be cost effective, but still the courts have various levels of appeals. And interestingly, the courts are not having the expected expertise, which is very much required for construction industry.
Thank you. We're almost out of time. So, Dr. Eddie.
Yes, okay.
Please, yeah.
Yeah, well, the cancellation of budget,
Yes.
I think, should not be related to the ongoing projects. It should be related to the prospective project. So when it is cancelled, the prospective project will not be performed. But if the cancelled budget is related to the ongoing project, yes, of course, it will result in a dispute. So the question is whether it will be an increasing dispute after the cancellation of budget. Well, it depends on what type of projects it is cancelled. But it should not be cancelled on the ongoing project, because if it is, then of course it will be disputed.
Yes, thank you, Dr. Eddie. I think the time is up. Apologies for the two other participants that we cannot answer the questions, but BIAMC can provide the email addresses of the three of us if you have additional questions. We would like to take a moment to thank our two speakers for today, Professor Inba and also Dr. Eddie. Thank you very much for sharing your knowledge and experience with us today. It has been a very practical and also insightful session for me and also all of the participants. We also would like to thank BIAMC for providing this webinar. For all of the participants, if you want to stay updated on the BIAMC future programs, please follow BIAMC at LinkedIn. The link was shared also in your webinar invitation. That brings us to the end of today's webinar. Have a great afternoon and goodbye, everyone. Thank you.